of constitutionalism would behoove this court to start like this, that expressio unius est exclusio alterius. To what extent am I saying this, my Lord? I make reference to our document, a bundle of authorities. The Supreme Court of Rhode Island, in the Constitutional Convention of 1883, found at page 887 of volume 2, stated this to that principle. We are of the opinion that the mode provided in the Constitution for the amendment thereof is the only mode in which it can be constitutionally amended. The ordinary rule is that where power is given to do a thing in a particular way, there the affirmative words marking out the particular way prohibit all other ways by implication, so that the particular way is the only way in which this power can be legally executed. My lords and my ladies, on to my first point, whether this court should order His Excellency President Uhuru Muigai Kenyatta to refund the public monies used in the unconstitutional constitutional process. My lords, on this is a novel issue for the following reasons. No court in Kenya has made a determination on Article 226(5) of the Constitution. In the whole of Africa, South Africa in 2018 is the only democratic country that ordered His Excellency President Jacob Zuma to refund approximately 1 billion shillings used in construction of his house. That was the taxpayers' money. And my lords, the history of the erstwhile Constitution of Kenya, with its 6 provisions on public finance, never provided for a provision akin to Article 226(5). And for that reasons, my lord and my ladies, the High Court's findings and declarations at paragraphs 784 to 785 of their judgment, respectively, were sufficient for an order to make good the loss of public funds. No evidence was needed for that order to be made. No evidence. It is strict liability. No evidence was needed. And if any evidence was needed, it was the evidence in the special knowledge of the appellants. Section 112. He who pays the piper plays the tune. My lords and my ladies, in buttressing this point and these findings and declarations, we rely further on grounds 2, 4, 5, 8, and 9 of the 76th respondent's notice of grounds for affirming the judgment of the High Court, dated 4th June 2021. Additionally, in buttressing these findings and declarations, we further rely on the 76th respondent's affidavit dated 27th June 2021 at paragraphs 7F, 7E, 8, 10, 18, 20, which affidavit has not been controverted by any appellants. My lords, I also invite you to look at the doctrine of public trust that we have talked about in our submissions. The doctrine is anchored in Article 73(1) and Article 1. Article 1 of the Constitution talks and says like this: mamlaka yote makuu ni ya wananchi wa Kenya na wanaweza kutekeleza tu kulingana na katiba hii. Mamlaka ya wananchi katika katiba hii yamepewa idara zifuatazo za serikali. My lords, there is a clear delimitation of who serikali is and who mwananchi is. My lords, I also invite you to look at the erroneous application of Article 35 of the Constitution, together with unreasonable and reliance of the affidavit of the Auditor General at paragraphs 47 and 48 of our submissions. pages 47 to 48 of our submissions. And therefore, in conclusion, my lords and my ladies, with such demonstrable disingenuity, should the court fold its hands under the doctrines enunciated here of political ripeness, mootness, political questions, I am afraid that the liberties of Kenyans and inalienable rights of the ordinary mwananchi would be suspended by a thread so slender than the hair strand that held the sword of the imperial King Dionysius over the head of Damocles. Thank you.
Council, do your best to stick to the time.
My Lord, I will request for 5 more minutes. And by introduction, my name is
You
Tokwale.
will have to stick to the time, Council. We really are very, very pressed for time. I wish you could start.
I'll try, my Lord. My Lord, my name is Tokwale Cinco for the purpose of the record.
Okwale?
Tokwale Cinco. And just before, my Lord, I proceed with my submission, I just want to make a point. The President has a right to champion the cause. And I think Justice Kiage followed that. What really happens when the Parliament is wrong? My Lord, my submission is that there are enough safeguards that provides the President with avenue for lawmaking. And just to cite maybe one, under Article 261, my Lord, the President can actually have the Parliament dissolved if it's not performing its function. And under Article 1.4, the people can actually, my Lord, recall their representative where they are not providing or rather carrying out their mandate. And therefore, that is not a justification to abrogate the President the power to amend laws under Article 257. My Lord, the basis also for Article 257, which gives the ordinary mwananchi the right to amend the Constitution, comes from Article 1. The reading of Article 1, my Lord, and this is actually factored also through the history of the Constitutional Review Commission and the final report. Under Article 61, the Attorney General, my Lords, have considered to the fact that the question of amendment has never been contentious in all history making of in the constitutional history making of Kenya. Therefore, the people of Kenya had a very clear mind that they intend to undo that power that enabled the rock executive parliament to mutilate the constitution. There was therefore no hard time, my Lord, to try to balance rigidity and flexibility to amend the constitution. And that it's my submission that the powers that the legislature, the executive, my Lords, enjoy is derived from the constitution. And when you consider like chapter 18, page 18, sorry, of the Njoya case, Justice Ringera talks about the constituent power being primordial, that over and above the constituent power, my Lord, being derived, it is also regional. That has to, it's two-pronged, my Lord, that the people are bound by the Constitution, but also the constituent power is original. And that actually takes us to a definition that in some instances that the people might not be bound by the Constitution. Any interpretation, my Lord, therefore, that says that the President is not entitled to initiate amendment of the Constitution through popular initiative, my Lord, I think will be the correct interpretation in that the people are the sovereign. They are the one who donated and constituted the legislature, the executive, and the executive can only act, my Lord, within the limit of the power that the people have donated. If the President, my Lord, therefore wants to amend the Constitution, and if it's indeed in the interest of the mwananchi, the President, my Lord, can actually resign and do that in his private capacity as a citizen. And I'll direct you, my Lord.
Mr. Siko, the point was well made. Please move on to the other one. You have 2 minutes, precisely.
My Lord, I'll just direct you to a decision by Justice Nambuye between the Ethics and Anti-Corruption Commission versus County Government of Meru, where it was held that in the regime of the Bill of Rights.
Which decision?
Ethics and Anti-Corruption Commission, my Lord,
okay,
versus Think County Government of Meru 2018.
All right.
Justice Nambuye and retired Justice Philip Waki presided over that, and it introduced a dichotomy where you view the state, my Lord, as a duty bearer and not the right holder. Therefore, the argument, therefore, that you can actually limit the right of the president to express his political rights for the interest of the local mwananchi, my Lord, actually survives. My Lord, as I conclude, I just want to point out what Dr. Thiankolu left in the interest of time on the issue of political question doctrine. And our submission is that in as long as it is the interpretation of this court that the popular initiative is an individual right, then the political question doctrine should not arise. I will direct you, my Lord, to abundance of authority, the case of R. vs. Miller, concluded by the Supreme Court of the UK, and also the case of Becker vs. Carr. Justice Brennan, my Lord, in that decision, brings out a distinction that whenever power is clearly delineated between each arm of the government, such that when we are arguing about the executive, there's a clear line that their mandate is to do with things to do foreign relations, defense. The argument, therefore, that one has abrogated the power of the other, my Lord, should not arise. And also, we provided an article by Professor Louis Henking, arguing that the political question doctrine is actually applicable in America and is an disingenuous legal mechanic to shirk off judicial responsibility. The Superior Court, my Lord, has unlimited and original jurisdiction under Articles 165 to interpret, my Lord, the Constitution, to promote in the interest of the local mwananchi, and that power is rightly delegated by the people under Article 1.
Thank you, Mr. Siko. Thank you very much.
Thank you, my Lord.
Thank you. Senior Counsel Karua, are you here? Sorry, Haminwa.